All rise. Court of Appeal in the 5th District in the state of Florida is now in session. The Honorable F. Graham Wallace, Judge presiding. All persons having business before this court draw near. Give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced. I would like to also welcome and notice the other members of the panel here today. I have seated on my right our Chief Judge, Judge Brian Lambert from Marion County. And I want to thank Judge Lambert. He has agreed to relinquish the center seat today, which is usually protocol on our court. When you're the Chief Judge, you preside over every oral argument session. He's made exception for that today because we have some special attendees, and I want to welcome Miss Jennifer Turner and Mrs. Heather Sistar and their class. They're middle school and high schoolers who are here to watch the proceedings here today. So welcome. And I also have, and we have joining us for the first time as a district court judge, Judge Adrian Soud from Duval County. This is Judge Soud's first oral argument session as a sitting district court judge. He joined our court in January, and we're blessed and honored to have Judge Soud join our court now and to work with him for many years to come. So welcome, Judge Soud.
Don't ask him very hard questions either.
And we have 3 cases on the docket. We've got 2 cases. The first one will be the Houston versus Kevin Rentmore case, et al. And we're going to do kind of a different protocol here today. I've let the attorneys know ahead of time that we would have students in the gallery. I understand the students have come armed with some questions. So after we do the cases, I'm going to ask the lawyers if they would mind just kind of introducing themselves to the students. And the students are not going to ask you any questions about the case. We're going to caution the lawyers not to make comments about the case, but more just kind of introducing the students to you and how you came about in your career, getting to this point in your career.
Are you going to do it after each?
Yes, and after each case we will do that, and then between cases 2 and 3 we're going to have a break. And then we will invite everyone over to the library for just a brief question and answer session with the members of the panel as well. So, with that being said, I'm going to ask everybody, if you have any device that makes noise, would you please silence that now? Either silence it or just turn it off so it doesn't interrupt the lawyers when they're making their presentations. I am going to assume that the appellant wants 5 minutes of rebuttal unless you tell me otherwise. The clock will be automatically set to that 5-minute warning. You'll get a yellow light when you get to the 5 minutes, and then hopefully you don't get the dreaded blinking red light, which means your time has expired. So with that, Houston versus Kevin Rentmore, and is it Mr. DeCunto? Is that correct? Or Miss DeCunto? Okay. And you may proceed.
Thank you. May I approach?
You may. Good morning.
Good morning. May it please the court, I am Poppy DeCunto, here on behalf of the appellate, Katrina Houston. This was an action for partition, where the court ordered the sale of the property instead of its division. The final judgment, which was a 21-page word-for-word adoption of the Appellate's proposed final judgment, must be reversed, and the court should be directed to appoint commissioners to determine the division of the property instead of the sale. This is because there was no substantial, competent evidence to support the trial court's finding that the parties would be prejudiced if the property was divided. It is clear.
Mr. Cunto,
Yes,
the facts of this case, it appears that there was quite a history between the parties. And my first question to you is, we're not able to sit down and sort all that out here at this court. It would take far too long. I think this trial judge was invested pretty extensively in the history of the parties. Why shouldn't we defer to the trial judge as far as whether or not the relationship in this situation had kind of, I guess, degraded to the point where partition or the sale was necessary?
Yes, Your Honor. We're not asking you to look beyond the court's finding that there was an interpersonal dispute between the parties. That was established at trial, and the court found that. However, that is one factor in a multitude of factors that this court was to consider. And presumably, any party that comes before the court for partition has an interpersonal relationship problem. If they didn't, they wouldn't be asking the court to solve their property problem. They would be resolving it between themselves. We cited in our case Young Properties, which is a Colorado case that says specifically that there's...
Well, when you say interpersonal, I mean, let's say my sister and I inherited a house from my mother, and, you know, I move out and she's still living there, and I say it's time to sell. I mean, I don't dislike my sister. I don't think I do, but, so, I mean, this seemed to be more here than just, you know, we were having a disagreement whether we should sell or partition it. They have cameras staring at each other, and they apparently litigate about their difficulties amongst each other. So that seems to be, isn't that a factor into the catch-all statute 64.209 that apparently you all decided to travel under?
Your Honor, it's actually not an enumerated factor in 64.209. I don't believe the parties' relationship is an enumerated factor.
It says any other relevant factor.
Yes, Your Honor, it is. But, Your Honor, I would point your attention to Schroeder versus Lawhorn, which is a second DCA case specifically between a brother and sister. There, the brother and sister apparently couldn't agree about anything. Despite that, the court still ordered division of the property because they were able to do that since the property was physically divided. There were two separate accesses on the property, and therefore the courts found that the parties would not be prejudiced by the division. Similarly here, the evidence established by every single person who testified that there was a separate access on the property besides the shared driveway. So even if the court had concerns about creating an easement for the shared driveway, the property could be divided in a manner that two accesses could be created. Mr. Rentmore testified that there could be fencing that could be put up to divide the property to protect their privacy interests, and Mr. Rentmore testified there could be fencing established to even protect the pond view. The property was clearly able to be divided regardless of the parties' interpersonal relationship in a manner that they would no longer have to be dealing with each other.
I mean, you also raised about the constitutional prohibition about selling homestead property. I mean, that's only applicable if you get past the hurdle of convincing us that it's divisible, that the trial court erred. I mean, you're not saying that you take my sister and me have a house. We can't split the house together. It's not a defense for her to say, well, that's where I'm living. That's my homestead. Have a nice day, brother.
Correct. If it's if it's one house, there's no question about divisibility.
So it's an issue of divisibility versus indivisibility, and I think actually if it's the resolution it is divisible, then I suspect that the Wentworths, excuse me if I'm mispronouncing that, Rentworths want to keep their home, and your side would keep their home, and so we wouldn't really get into the homestead issue anymore.
Correct. At that point, neither party would be losing their homestead. And that's why division is really one of the presumption that's supposed to apply here, especially in the homestead situation, because your homestead property and any property is a sacred right. So there's a presumption that the property is supposed to be divided unless there's prejudice to the parties. Here, every single factor weighed in division. The only factor that had anything to do with the court's ruling as to why it wasn't divided was the personal relationship of the parties. That can't be the driving force. He completely ignored all of the evidence about the monetary value of the property. Here, all of the evidence submitted by both Mr. Hall, who was Ms. Houston's expert, and Mr. Rentmore opined that the property would be in the range of $527 to the high 500s. The Rentmore's expert, Mr. Carter, testified that the property as a whole would be worth approximately $650,000. The judge said on the record and in the final judgment that he greatly discounted Mr. Carter, the Rentmore's expert.
But not wholly.
Not wholly, but to some extent.
You like the 650 number.
Well, if he greatly discounted it, he didn't like the 650 number, and the judge specifically didn't ever make any findings as to the value of the property.
Did the judge make a comment about, and the buzzwords here are credibility? The judge found one expert to be more credible than the other expert, is that correct?
I can't say that he specifically stated the words credibility on the record. However, he did say specifically that he did not find Mr. Carter's valuation as to specific comparable properties to be something that he agreed with, that he could tell by looking at the comps on his own that the property was not worth what Mr. Carter was claiming that it was worth.
Did he also examine, I guess, and evaluate the credibility of the parties? And specifically, I'm talking about your client, Ms. Houston, words to the effect of, we're all good now, the relationship is all good, we're not having any problems here, but the trial judge was presented with evidence which included your client's cutting off the power to some of the structures on the other side of the property, and the fact that there was some type of a drainage issue with regard to the pond, which resulted in the drainage. Similarly, the rent wars would be, I guess, dependent upon Ms. Houston and her conduct with regard to draining of the pond. Is that correct?
That is correct. However, the drainage could easily be redirected. So the fact that the drainage right now crosses in a manner that would be on the Rentmore's property does not mean that it couldn't be corrected in the final determination about where the property line should go.
But that would also be a consideration, right? You're making it sound like it would be very simple to divide the property, but there's these logistical support problems that are going to have to be worked out in order to divide the property. Would that occur before or after the division?
During the division, if your honors were to remand this, a special commission panel would be appointed who would decide exactly how to divide that property and would make those determinations. So that would happen at the next round in front of the commissioners. And just as in Schroeder v. Lawhorn, there are times when you're dividing the property that you have to create these logistical changes to the property. That doesn't take away the sacred presumption that the property should be divided.
I guess I have one more question, too, with regard to Mrs. Houston's conduct. Was there an event, I believe, in the facts of this case, where Mrs. Houston parked her RV or an RV in the common driveway, which resulted in some video cameras being pointed directly at the Rentmore's property? Are those facts of this case?
I don't recall an RV being parked there. There was definitely testimony that she had parked her truck in a manner that they thought impeded their ability to use the driveway, which would be alleviated by ordering, when you divide the property, that the other driveway be used by Ms. Houston instead of the shared driveway. The evidence that I recall about the RV is that the RV is actually parked on an adjacent lot to Ms. Houston's property, which is another factor that the court overlooked. If the property is not divided, then the adjacent lot to this one big parcel will have no access to the road.
Did the judge, I mean, I know that's one of your arguments, that the judge gave no weight to that and should, and that's part of the error that you argue should justify the reversal and remanding here. But I mean, at the end of the day, didn't the judge say in the judgment that basically, even if I take that into consideration, it doesn't change the result here? So why, I mean, for example, or by analogy, you know, when I was a judge on a felony docket, you know, one of the things you'd have the score sheets as to the sentence points. I always made it a practice of saying, for the benefit of, you know, these geniuses up here at the 5th DCA, I always made it a practice of saying, look, even if there's any error in the score sheet, it's not going to affect the sentence that I'm about to impose. How is that not analogous here to the scenario saying, look, I don't think I should consider it at all. If she wanted to buy a landlocked property, that's between her and whoever. But even if I should consider it, it does not affect the overall decision here. Doesn't that make it if it's error, doesn't that make it harmless?
I don't believe so, Your Honor. I do think the situation is analogous, but the reason that it's different in this circumstance is because this court, the lower court, was predisposed before any evidence to find that the property could not be divided due to the parties' relationship. And what I would argue, Your Honor, is that he came in with that predisposition.
What makes you suggest that from the record?
On page 12 of the record of the transcript on April of 2021, before opening argument, the court said specifically, I'm hard-pressed due to, we had submitted a statement of facts, a joint statement of facts, that indicated exactly what the parties' relationship was. After reading that joint statement of facts, and before we ever made any opening argument, he said specifically, "I'm hard-pressed to figure out how these people should remain neighbors due to what I've read in the statement of facts." That's problematic for two reasons. One, the fact that you order the property divided is not the same as ordering them to remain neighbors. What it allows them to do is choose how to deal with their property independently of one another. If you divide the property, Ms. Houston can choose to stay in her house, or she can choose to sell it. If you divide the property, the Rentmores have the same option. Here, with the sale, the parties are now all being forced to sell the property. No one is being allowed to retain their rights, and this overlooks the fact that the Rentmores, the only substantial competent evidence in the record as to the division of the property with the resulting lots, would be that the Rentmores would have a lot that was worth approximately $320,000. Even accepting their expert testimony, Mr. Carter, that the property was worth $650,000, that's only a $5,000 difference between the total value of the property, accepting his opinion, and the only evidence as to the value of the resulting parcel. So there's no concern that needs to be dealt with in terms of will they be prejudiced if it's divided because they would remain neighbors. They can sell their lot and still receive the exact same value. And that's the position they're in now, is they're either going to sell the total property or they're just going to sell their lot. The evidence was clear that they wanted to sell the total property because they're hoping they can swoop in, buy the entire property, and buy Ms. Houston out so that she loses her interest in her homestead property. The other reason that the court's statements were problematic as to telling us in advance of opening argument that he didn't see any way that the property could be divided because he didn't want them to remain neighbors, shows that he was using the wrong presumption. The presumption is that the property should be divided unless there's prejudice shown.
But didn't the judge, though, then say in the judgment, even considering the statutory presumption of divisibility, the burden has been met by the Rentmores, excuse me. By the way, how do you say your client's last name? It looks like Houston.
It does look like Houston. It is Houston. And the Rentmores are the Rentmores.
All right. Yeah, so if anything, I'll get that right before this ends here.
He did say that in the final judgment, Your Honor, and that's problematic because the final judgment is simply a 21-page word-for-word adoption of the appellee's.
Well, I know you're unhappy about that, but I mean, and I know one of the supplemental authorities that you are correctly moving to strike was something that I wrote that talked about Perlow. I actually still remember it. I wrote it last year. So it wasn't there time, though, for you to object or do whatever when that proposed judgment was submitted to the judge. So, Perlow in those cases is the judge signed it, hours after it was submitted.
Yes, Your Honor.
Is that the distinguishing event here?
No. Here, the court specifically found at the end of the presentation of evidence that he was inclined to order the sale due to the parties' relationship. He then said, to the extent you want to try to change my mind, I will allow you to submit proposed findings of fact and conclusions of law, which is the task we went down. He said, before even doing that if we chose to do that, we would be giving the Rentmores a free hand on writing what the final judgment is going to be. That's the record at 611. That shows specifically that he delegated his judicial authority to the Rentmores and was going to accept whatever they submitted, which is exactly what happened here. At the time that we submitted them, we were properly preserving all of our arguments and objections to what had gone on and to his...
Did you move for a rehearing after that happened?
We did not move for a rehearing after that happened, Your Honor, because we didn't think that the final judgment was supported by the substantial competent evidence of the case. All the substantial competent evidence of the case showed that the value of the property as a whole is less than the value if it was divided, that the property was Ms. Houston's homestead property, that the Florida Supreme Court at Tullis v. Tullis in Note 2 specifically found the court should make reasonable efforts to preserve the homestead interest if the property is divisible. And the court found that because of the parties' relationships, that the fact that there would be easements that were required rendered this a situation where the property couldn't be divided. However, that finding overlooked the fact that, again, every witness testified that the easements were not necessary, that to the extent that you couldn't put up a fence to deal with the pond view, that the loss of a pond view had negligible value on the property. Mr. Carter specifically testified that the value of the pond, if you lost the view, was only a $2,000 to $5,000 deduction to the value as a whole. Further, McNamara versus Mossman, a case that we cited in our brief, says specifically that the loss of an attribute alone does not generate prejudice. Therefore, the substantial competent evidence that the court relied on, strike that. There was no substantial competent evidence to rely on, just as in the Thompson versus Mitchell case, in the first DCA case. There, the court decided that the property should be sold based on this one homeowner's unsupported testimony that if it was divided, you couldn't hardly get to her property. The first district said that was in error, and the court's finding that the property should be sold and not divided should not be accepted. I'd like to reserve the remainder of my time for a rebuttal, please.
You may.
May it please the court?
Yes.
Aaron Sprague for the Appellees. The first thing I want to do is address some of the issues that were raised by my colleague on the other side.
Yes. Why shouldn't we grant the motion to strike your supplemental authority? Because these are cases that certainly predated your briefing in this case. I mean, it seems, I wholly agree with your opposing counsel that this is an abuse of the notice of supplemental authority rule of simply, well, you can shake your head no. I do think it, and I think it's a sanctionable event, but I don't have that authority presently under the rule. But I mean, you don't get surrebuttal. That's in essence what this is. I know you don't explain, you don't argue in your notice, so I'll give you that. But I mean, to cite cases that predate this case.
Your Honor, I have no intention of arguing with the court on that. The cases cited go to legal issues that were raised.
I know what the cases are cited for. I get that, but I mean, you know, you could have argued that in your answer brief. I mean, obviously they were unhappy about the wholesale adoption of the proposed judgment from your trial counsel.
We did argue them in our initial brief.
Well, you should cite those cases because they existed. That's my point.
And my only answer to that, Your Honor, was when we drafted the initial brief, we were in front of the first DCA and therefore cited first DCA case law. When we were transferred to the fifth DCA, we thought out of abundance of caution it would be wise.
You don't cite fifth DCA cases to the first DCA? What, did they hurt their feelings or something like that, or what?
No.
I'll make R&J about that when I see them.
Mr. Sprague, there is a first DCA case, Eaton versus Eaton. You still cite that first DCA case. You cite two fifth DCA cases, but all of them, we've got a 2020 case, 2019 case, and a 2022 case.
Correct, Your Honor. And again, I don't want to argue the point with the court. I believe that the legal principles are well established, even if the court were to not consider those cases. And if the court is inclined not to consider them, I don't have any intention of arguing it with the court on that point. All right. So the first thing I want to do is address squarely some of the things that were raised in my colleague's oral presentation. First, the comment that fencing would fix the camera issue, that was raised in their initial brief. That factual statement is misleading. If you look at the quote from Mr. Rentmore in the transcript at pages 274 and 75, he doesn't say what they claim he says, and I'll let the court look at that at your convenience. Also, Your Honor, Judge Wallace, you were completely correct. There was an incident where the RV was moved from its position on the side of the property to the circular drive, which directed cameras at the Rentmore's property, and that is also in our answer brief. The next thing that I want to address is the issue from page 611 of the record where counsel claims that the court abrogated its obligation to construct an order of its own and was just going to delegate to the Rentmoors Council. That is also misleading. What was going on, and I encourage you to read that part of the record in context, because Houston's counsel came into that hearing. The court asked if they still wanted to do competing orders, and the portion of the record that they're citing to is the court at Ms. Houston's instigation, still indicating that they wanted to submit competing orders. And so at Ms. Houston's instigation, the court gave them that ability to do so.
How much time did they have to object to your side's proposed final judgment before it was entered?
I believe it was 4 months, Your Honor. I could be wrong, but it was a matter of months, not days.
I don't see it in the record, but maybe I missed it in the record. Were there any objections raised to the proposed?
There was not. And Your Honor is right. There was also not a motion for rehearing, which is something that we will address here as I turn my attention to preservation. Because there are several preservation issues with the position of the appellant. First of all, the legal standard that they argue should be used to analyze this case. In the trial court, they argued 64-209.
How did that come about anyway? You look at the statute, A, it became effective after the case started, and B, it talks about what commissioners should consider, not a trial judge. But and I know you were not the trial counsel, but it sounds like everybody traveled under the 64.209 right of access. I'll use that for partition purposes.
Your Honor is exactly correct. Why we are here arguing 64-209, both sides, is because that's what everybody argued in the trial court.
Okay.
However, in their initial brief, they abandoned their arguments under 64-209. It's never cited, never mentioned once. Certainly, they never argued that the 64-209 was misapplied. They urged the court to adopt the Amjur approach in stating that the value of the property is the only thing that matters. And then, when we point out that that was contrary to Florida law, they shift ground again in their reply brief and argue for the first time that the court misapplied section 64-209. And that is an argument raised for the first time in reply and therefore not preserved. And that's going to infect a lot of things that we're going to see in their arguments going forward.
What about their argument that, okay, let's assume this court says, all right, we affirm that it's indivisible, but we don't agree that it should be sold in the manner that it's been directed to be sold by the judge. You have to have a different process under the statute. And oh, by the way, we didn't agree to anything like that whatsoever that the judge ruled in.
Your Honor, let me address that squarely, because that also has not been preserved. Nothing about the method of sale was preserved. In fact, they agreed to it in the trial court, and we cite that in our briefing. And I'm going to read to you the quote. We are very concerned about some kind of bidding war or something going on between the parties. We obviously think that the correct result here is to divide the property, but if Your Honor is not going to do that, then it should be set up in the manner that you're discussing in terms of a receiver.
So you believe that the trial counsel at that point for your opponent should have said, Judge, I don't think that the property is indivisible. It should be divided by commissioners, but if that's not the way you're going here, then we want to make sure that it's then sold at a public sale or consistent with the statute.
Correct. That's exactly what they should have said.
At that point, the judge, it's squarely hitting him in the face saying, okay, if that's the route you're going, chum, follow the statute.
Right.
That's how it should be sold. But when you tell the judge otherwise, the judge is free to rely upon your representations.
Right, because it's invited error, Your Honor. And then the next thing, plus the case law is clear that you can do a non-public sale if the parties consent, and that's consent. Now let's take the position of the appellant, that this is not consent and that this error appears for the first time on the face of the final order. Well, then Your Honor is correct that they had an obligation to raise that by motion of rehearing. For rehearing, because errors appearing for the first time on the face of a final order must be raised in rehearing or they're waived.
Do you think the motion for rehearing rule that's been amended by the Supreme Court talks about you need to raise those things if there's insufficient findings, or just, give you a second chance to, because there's that the angst between the rule of, don't re-raise something that you already raised just to complain about that you lost, as opposed to if there's insufficient findings, bring it to the judge's attention so she or he can correct that before it goes up on appeal.
Right. So here, what the position that they are taking is, this is an error that didn't occur until the final order. So it's not something that they argued, that lost on, and then we're going to re-argue. It had been something that appeared for the first time in the final order that they needed to raise on rehearing in order to be waived, in order to be preserved, which they did not do. So there's just...
And they could have done because they did it here.
Yeah, exactly.
And that's something that, something that Judge Eisnagel wrote in his concurring opinion, and to my
Precisely, Judge
one
Lombardi.
case that we're not going to talk about.
Right. So I want to just touch briefly, and I don't want to belabor this very much longer, but I want to just raise a couple of more preservation issues, whether the court erred in considering the relationship of the parties. Again, in the trial court, they take one position. In the initial brief, they say that it's an error as a matter of law, relying on a bunch of foreign cases from other jurisdictions. And then in the trial, their reply brief, they say, well, it was right for them to consider that, but it was given too much weight under 64-209, an argument.
To be quite frank, I think that's kind of their common theme throughout the entire case. The trial judge put too much weight on the relationship between the parties and basically discounted or didn't give any weight or very little weight to the value of the property as far as the sale or what form of sale to take place.
Very good, Your Honor.
That's a fair assessment, correct?
I think that one of the things they argue substantively throughout is the weight that the court gave to the relationship between the parties. Now, let me kind of address that substantively because Your Honor raised it, and I'll endeavor to show why what the court did was proper under 64-209. 64-209 gives 7 factors to consider, one of which is a catch-all, which we've already discussed. The other, under 1A, is the practicability of dividing the property in kind, whether it's practical to do that. 64-209-2 says that any one factor can't be determinative without considering all the factors. Now, what that statute does not say is that all factors must be given equal weight. It doesn't even say that one factor can't be determinative. It just says all factors must be considered. So if you look at the court's order, it follows that to a letter.
Well, the catch-all subsection, though, says any other relevant factor, and I think gleaning from your opponent's argument is whether these people like each other or don't like each other is not relevant to this, so it shouldn't even come in the mix. What do you say to that?
It is relevant for the following reason. All of the testimony from Houston, their expert Hall, was that the property, in order to be divided in kind, needed to be done with a number of easements imposed. And again, to quote, the parties stipulated to a portion of Brian Hall's testimony as follows. Brian Hall rendered no opinion of the subject property as if divided and not encumbered by any easement. In other words, his testimony was that if this property is divided in kind, you need to impose easements, one of which was a negative easement for pond view, the other which, despite the separate access point, was an easement for joint use of the main drive. And he had no opinions, in this case, other than in-kind division would result in easements. So what does Schroeder teach us? Schroeder actually supports us. Schroeder teaches that if you are going to divide a property in kind, easements are not practical if the parties have an acrimonious relationship, because in all fairness, what you then ask the courts to do is be a supervisor ad infinitum of that property as these people who can't agree on anything fight over their joint rights under these easements. So it is relevant because it goes to the issue of whether the property can be practically divided. And so, going back to 64-209-2, there is nothing in the statute, in that language, that says that any fact or factor, or set of fact or factors, cannot be given great weight, which is what the court did and what it was at liberty to do under the statute. The court says it's taking into account all the factors, notes that the statute does not require it to weigh all factors equally, chooses 5 factors to highlight in the order, and says that it gives great weight to the relationship of the parties, which it was entitled to do. What we have heard, and I think what was conceded by my colleague, is that there was competent and substantial evidence to support ongoing relationship issues between the parties. And because there were, the easement plan testified to by Mr. Hall is not practical under Schroeder, and therefore the property cannot be divided in kind without prejudice.
So you basically see this case as the trial judge was given competing expert testimony, one as to its divisibility and one as to its indivisibility of the subject property. The judge, whatever comments that he might have made about discounting your side's expert, at the end of the day, it was a weighing of the expert testimony, and the judge found in favor of your side, for lack of a better term, so at least thought that the expert witness testimony was more credible. And under those scenarios, we don't reweigh the credibility determinations made by the judge, and therefore the expert's testimony on your side is competent, substantial evidence to support the ruling, and you ought to affirm it and have a nice day.
Substantially that, Your Honor.
Free of softball, you could say, yeah, it's good.
Yes, substantially that. I think there's some nuance there.
That's what your argument basically is. I mean, I know you're addressing the various arguments cogently raised by your opposing counsel, but at the end of the day, that's kind of
right, and it goes down to what the competent and substantial evidence standard is. This court, under that statute, or under that standard, under Clegg and Griffin, it doesn't ask if there was evidence to support a different finding. For instance, it doesn't get into, could the property be divided without easements?
I mean, in essence, you're saying if the judge said, we like Mr. Hall's testimony, and he agreed with Mr. Hall's testimony, ordered partition, you basically would have to say with a straight face, well, you know, that's, judge weighed the competent evidence, he thought that was more competent, and I'm dead in the water here.
Correct. And
probably politer than that. But.
In this case, Hall offers testimony that easements would be necessary to divide the property. That's competent and substantial evidence, and this court, it's not within the analysis of the appellate court to then reweigh or look at the evidence to see if there was something else the trial court could have done.
You want to tell Judge Soud that, you know, don't be a trial judge anymore than about weighing evidence. You can't reweigh evidence up here.
Your Honor, I want to touch briefly on the homestead exemption issue. Again, here we have a preservation issue in that
I think your opponent, I mean, your counsel's conceded that. I mean, if it's divisible, then that applies. If it's indivisible and we support that, then you don't get the homestead exemption anyway.
I think where the disconnect comes in is this, and I'm running short on time, so I just want to make this point. There was an
He'll give you more time. He's good.
Maybe.
There was an implication that the court gave this no consideration. And the court did, and I would encourage you to look on page 600 of the record where the court actually found compelling Ms. Houston's testimony about the fact that she made this not only her residence, but her home. And notwithstanding taking that into consideration in Houston's favor, ordered a judicial sale of the property. So even if this argument has been preserved, which we contend it hasn't, the court took that into consideration when dividing the property. Your Honor, finally, let me turn briefly to the value of the parcels if divided in kind, because there was an implication that the court did not consider that at all. The court did. That is on page 589 or 598 and 599 of the record. It had a competent and substantial basis to conclude that it'd be worth less because of the easements imposed and because of the nature of the property as rural acreage. That's also in the record. You can look at our briefing to find the citations there. Finally, there's one thing I would like to point out, and it has to do with the relationship of the parties and the argument that this was the sole thing that the judge took into consideration. That argument is made in the reply, and the court and the appellant has given 12 citations where she says it shows that the court was only considering this. If you look at those 12 citations, and I would encourage you to do so, what you're going to find is that one of them, it's not even the court talking. 5 of those, the court doesn't mention the relationship at all. It just indicates its position that it's going to be difficult to divide the property in kind. Of the remaining 6, nowhere does the court say this is the only thing I'm thinking about. Clearly the court was concerned about the relationship of the parties, and it was right to be and had the ability to be under the statute. But if their court had ever said, this is the only thing I'm considering, I'm sure we would have seen that in bold in a block quote in briefing somewhere. And we never saw it because it never occurred. Just because the court says that it's worried about one thing does not mean it's not worried about other things. And that is reflected in the order, and I see that I am out of time.
Thank you, counsel. And counsel, you have about 3.5 minutes.
May it please the court, I'd first like to address Florida Statute 64.209 and why it was discussed. At common law, the courts were allowed to consider any factor when determining partition to determine whether or not there would be prejudice. 64.209, which was created after this case and was not binding on the court, as we pointed out to the court in our initial brief, we found was instructive because it was a codification of factors that existed at common law. 64.209 was created specifically because despite the fact that there is a presumption against the sale under the common law, courts are routinely selling parties' properties. Therefore, the Uniform Heirs Partition Act was created and has been adopted across many states to combat the very problem that we have that happened in this case. This is Mrs. Houston's home. She is the person who found the property. She has done everything she could to maintain this property, to improve this property. We are talking about a property that has 2 houses sitting on 4 acres, that has different water systems, that has different electricity, that has different access availabilities. The property can be divided, and under Tullis v. Tullis, it should be, to preserve her sacred right to her homestead. To look at this and say the fact that the parties can't get along is a reason to force her from her home, that's why this statute was created, because courts would look only at the value of the property and not the other factors to realize what are the personal attachments that people have to their property. So here, the court erred in elevating the factor of the parties' relationships. In Schroeder, as we mentioned before, the brother and sister did not get along. There were 2 separate access points, so the court said, we're going to divide the property that way, give you guys your separate access. They specifically said, we don't need to reach whether or not an easement by necessity would be required here. That's not saying that easements by necessity can't be ordered. They're saying under the circumstances of this case, we don't even need to go there because we can separate the interpersonal problems with these different accesses. That's exactly what we have here.
Let me ask you this, counsel. Let's assume this trial judge decided not to make gratuitous comments that, obviously throws issues into the fray here, and just had just sat and listened as a trial judge and listened to all the evidence, let everybody present their case and present their experts, and said, okay, I'll decide, and he writes a judgment that's similar to what you're unhappy about today. The question I posed earlier to your opposing counsel was, okay, if the judge is simply listening to competing testimony primarily from the experts and sides with one of which why wouldn't that be kind of difficult for your position on appeal here, because we obviously don't reweigh why the trial judge thought that the testimony of that expert was more compelling. Just like I threw out, if the judge said, I like what Mr. Hall said, you'd walk in with an easy win today.
Because Mr. Hall didn't have any evidence to back up his opinion that the
Mr.
resulting...
Carter, you like Mr. Hall, right?
Thank you, Your Honor.
You make it
Yes.
a lot harder for you if you told us Mr. Hall didn't, so.
Mr. Carter did not have any evidence to back up his opinion about the resulting parcel value. He simply stated without any data that he thought it might be less. There was no expert opinion rendered by Mr. Carter as to the value of the resulting parcel. Specifically as well, Mr. Hall did not say an easement was necessary. As we cited in our brief, he testified specifically, would your resulting conclusion about the value of each parcel be different if there was a separate access to the property versus a shared driveway? Answer, no.
Counsel, I'll give you a moment to wrap up, but you're at the end of your time.
Thank you, Your Honors. As it's demonstrated in our briefing and through the cases, there was no substantial competent evidence to order that this property should be sold. The presumption that the property must be divided so that the property owner's property rights are protected should be applied here. The court should overturn this ruling and tell the judge to appoint special commissioners to divide the property. Thank you, Your Honors.
Can I ask you just one thing?
Yes, sir.
Is this your first time appearing in front of our court?
I appeared through Zoom once. This is my first time I get to appear in person.
Okay, you did a nice job. Thank you, counsel.
Thank you.
Thank you, counsel, for your arguments. And now, if counsel will indulge the students that we have here today, I think they're armed maybe with a couple of questions too. But to start out, we can start with Ms. DeCunto. Could you just give maybe the students the benefit of your background, your education, and how your career path led you to be here today in front of our court, please?
Sure. So I'm from Jacksonville, Florida. I now live there on purpose. I went to Wake Forest for my undergraduate, and then I went out to Los Angeles to the University of Southern California for my law school. Loved law school, never wanted to stay in California. I wanted to be a public defender for my career. I wanted to defend people that were possibly receiving the death penalty. So I became a public defender down in Miami. My husband's from Los Angeles. It was easier to get him to Miami than to Jacksonville. Luckily, he did not care for Miami, nor did I, so I got him to move to the public defender's office in Jacksonville. Love that office. As you're an adult, things change in your life. I had my first child, and things changed for me. And I wanted to prioritize raising that son and then my second son. And I had an opportunity to join a private law firm that would give me the flexibility to stay at home and work for them and also have my son. Luckily for me, I love business cases. This case is a little bit different. It's a little bit, well, we're not talking about this case. I love business cases. And so the pressure was off when you were no longer worried about is someone going to go to prison. That's hard. When you're arguing about money, there are lots of times business resolutions that people can reach. And so for me, I also found that the business law, you get to hear and work with lots of really complicated areas of the law. And when you're a public defender, a lot of times you take that when you're dealing with constitutional issues, things like that. But on a day-to-day basis, a lot of times it's really just fact-intensive and trying to figure out, you're not necessarily dealing with really diverse areas of the law.
Let me ask you, counsel, how did you get in the world of appellate law, like you are here today?
So I love briefing, and I like the appellate law. Once the factual issues are distilled, so that you're not supposed to be arguing about what the facts are anymore, you're just really arguing about complicated legal issues. And I think that that's fun. So it's nice to kind of distill these complicated legal issues into a place and get to present them to.
Were you the trial lawyer down in this case?
I was a trial lawyer in this case.
So there's a difference between preparing for a trial and preparing for us here on appeal?
Yes, and I think it's hard when you're a trial lawyer to switch that, because it's very easy to just keep arguing what you argued before, and now when you're here, you're not getting to make the same argument that you made to the lower court. Now you're having to say to this panel why the lower court was wrong. So to the extent you're just trying to re-argue, you're not gonna get very far. So it's very different, and I think sometimes, a lot of times, lawyers are only appellate lawyers. They're not necessarily the trial court lawyers, and sometimes that's an easier thing because then you're always in that lane. I think it's hard to switch from being the trial advocate to the appellate advocate.
And counsel, how many hours can you estimate you prepared to get ready for this oral argument, which lasted, what? They saw it here today. The whole thing lasted 40 minutes, so.
So first, preparing for this, it starts with the initial brief, right? And the briefing takes a really long time, multiple hours, a lot, 20, 40, I'm not even sure. And then we also have the chance to do a reply brief since I'm the appellate, so that's also a lot of time. And then it's a question for me of distilling everything that we've said in those briefs into now a 20-minute presentation. And knowing that you're going to be kind of the victims of the court's questions. So you can create whatever you want to say, but that doesn't mean you're going to get to say that. So you have to be ready to be nimble, to not say what you just had on the paper, and to answer what the court's interested in. Because
And many people have thought they've been victimized by Judge Wallace's question.
For their context, your initial brief's 47 to 48 pages. Not a small undertaking.
correct.
The answer brief's also substantial in its length as well.
And many people have been on receiving ends of Judge Lambert's compound questions, too.
My overwhelming humor.
I only mean that there are things that you want to say, but what is important is to listen to what the courts want to know, because that's who's making the decision. So it's more important to answer what they want to know than to tell them something that they're not interested in.
What do you do to try and anticipate what we're going to ask, which is a very hard thing for anybody to have to do?
I have, for my argument, I create every time, I have done oral arguments in other places, and I learned this in law school from moot court, and so I outline every single thing that I think I could ever say, highlighting cases and things like that, so that when the court asks me a question, I know where is that topic in my outline, and how am I going to go to it, and just use this as a cheat sheet. And I find this really helpful because then I'm not flipping through a bunch of papers, and it distills your argument, because there's only so much you can keep. This is actually pretty good. I don't have these 2 pages filled, So I try to just distill it down as much as I can, to just have it be a cheat sheet, to then be ready to specifically cite to the record or anything I think that they could ask about.
Thank you, Mr. Kunto. And Mr. Humphrey.
Sprague.
Mr. Sprague, I'm sorry, Mr. Sprague. Yes.
Same question?
Yes, yep.
So I grew up in Seattle, Washington, which is geographically about as far as you can get away from here. I went to Brigham Young University, and then I went to the University of Michigan for law school. And then we applied for jobs everywhere that we had family, and we ended up in Jacksonville. And so I was with a firm of trial lawyers for about 6 years. And then I suffered a temporary bit of insanity, took a job with the Oregon Department of Justice, moved back to the Pacific Northwest for 3 years, and then found that it was difficult to be in public service and still raise a family. And then, by the oddest coincidence, was able to get back on with that same firm of trial lawyers, move into the same house, put my kids back in the same school. So it was like I was abducted by aliens for 3 years, and then dropped back into my old life.
Back into the sunshine.
Right. And so how I came to be doing appellate work as opposed to trial work is like this. My bent, my interest in kind of what I'm best at has always been briefing and arguing to the court. So there was a system that just kind of evolved organically into this firm of trial lawyers that I'm with, that I do all the talking to the judge. So if there's motions in the trial court, if there's arguments to be made in the trial court, evidentiary issues that come up during trial, I handle all of that. If somebody asks for a case to be dismissed, I handle that. And so over time, I became what we call the judge whisperer. And then there is a very, very good firm of appellate lawyers in Jacksonville who we have worked with extensively. And I came to be associated with them, and I wear then two hats. An appellate lawyer hat with this firm of appellate lawyers, and I still do trial work with this firm of trial lawyers. Because everyone just kind of realized that what I do is much more similar to appellate work and trial work, and so that's how I became to be in the appellate. I've done several oral arguments, briefed a number of cases, and I really enjoy it.
And trial work is stuff like maybe students have seen on television where there's a jury. There's no jury in this case, but there's a jury, and the lawyers call witnesses, and the witnesses are sworn in, and they testify about things, and then either a jury or a judge makes a decision based upon what's been testified about, whereas obviously we don't take evidence here. We just talk about what happened, and you're trying to tell us that good job below, no error, nothing to do but just affirm it and go on and let the judge's ruling stay where it is, whereas your opponent thinks that wasn't the best choice based on the facts of the case.
Right, and that's where we are in this case. There's been cases where I've been on the other side, where I've been arguing for reversal. Trials are a lot more boring than what you see on TV, and there's times when a jury will get actually sent out of the room, and the court has to take whether a certain piece of evidence is admissible, whether we get to show it to the jury, and I will be quietly lurking in the back, and I will come forward to the bar and argue in the trial court, because that's kind of my role when I'm wearing my trial hat. So here's what I did to prepare for today. I prepare my outline. I look at the points that I think are things that I have to address affirmatively, and then I try to prepare for questions. And then about a week ago, my colleagues and I had a mock oral argument where they took on the role of court, and I took on the role of the person arguing, and they peppered me with questions so that I could be prepared for the panel's questions. And in terms of time, getting ready is a long effort. There's briefs to be written, that takes a long time. And then in preparing for today, in addition to the oral argument, several full days.
Because this is your one shot. In other words, you don't get to say, boy, when you're riding back up to Jacksonville, say, I forgot to talk about that. Maybe I can call them up and we can come back and have another chat a little bit about some more stuff that you thought about when you're on I-95.
Judge Lambert is exactly correct. It is your one shot, but I will tell you this, and I'm sure Judge Lambert will tell you the same. That's not going to keep me from getting on I-95 back in Jacksonville and saying, you know what, I really should have, because that's just the nature of it.
Mr. Sprague, how many times have you come to a court, done an oral argument, and with all the preparation that you've had, and then when you leave the oral argument, you think about the number of questions that either was asked of you in practice versus in the oral argument, and the two don't match up?
So you never can fully anticipate what a court is going to ask you. You can come pretty close, and if you prepare well, I think that you're going to be ready, at least in terms of topics that are going to be addressed. I think you can be ready for probably 80–90% of what the court's going to ask you. But sometimes the court's just going to ask you something that you didn't cover in your non-formal argument, or that wasn't in your notes, and then you just got to trust your own knowledge of the case, your own persuasive ability, and your knowledge of kind of what is persuasive and what is not.
Let me ask you this. Do you prefer the panels ask questions or not ask questions, or does that depend upon which side of whether you're the appellant or appellee?
Oh, that's a really good question, Judge Lambert. I'm not sure I have a preference. I've had very active panels. I've had panels where I have not been asked a single question. And I would add this, attorneys, when you leave here, you always try to read the tea leaves, and you're like, oh, well, they ask this question, they ask that question, does that indicate what they're thinking here or there? And, can I glean from what the trial or what the appellate court asked me, whether I'm going to win or lose? And you're always wrong. I've had cases where, for instance, the court did not ask me a single thing, and within 10 days I got an order saying that I lost. I've had a time where the court didn't ask me a single thing, and within 10 days I got an order saying I won. And it's just kind of, you prepare, you address what the court addresses, and you trust that a correct decision will be made.
Have you ever left an appellate argument and thought to yourself, wow, those 20 minutes really moved slowly?
You can all see the countdown clock. I will tell you, the time evaporates. You start talking about preparing. I'll go through and I'll make sure that I can make all of my affirmative points comfortably within the time allowing for questions. And then when you get up there and you're kind of working through your outline, you're answering the judge's question, you look at the clock and all of a sudden you realize you've got 6 minutes left. And yeah.
So I think the answer to that question is no.
No. Time never drags. Time never drags, especially when you're in front of a panel that's pretty active.
And it's all from the perspective, because I know Judge Wallace and I, we've had colleagues in the past who would lean over and say, is this almost over? Is this are we almost done yet? Or they'd be clicking their pen or doing this. So, we're all former trial judges too. So sometimes, as a trial judge, you sit there and you're listening to the witness and says, is this ever going to end? And then, but when you're in the fray, it just kind of goes by. You're thinking, well, I'm here for 2 or 3 or 4 days of trial, and it kind of goes by faster than you think. But it's all perspective.
Thank you, counsel. So, does anybody from the gallery have, from the students, a question? How about one question for each lawyer? Yes.
Grayson's going to go first.
Grayson.
You guys stand up. You guys tell them who you are.
I'm Grayson, and I have a question for you. Would you ever want to be a judge one day?
Definitely.
How come?
Because I just know that some lawyers become judges at some point, and I was thinking, maybe some people stay lawyers for the rest of their career and don't ever become a judge.
So I agree with you, and different lawyers want to be judges, and some lawyers do, and some lawyers don't. I think that there are judges or lawyers that really love the performative aspect of trial court and being in the trial and the kind of adrenaline you get with that, and those people that I know, that's their role and that's where they want to stay. Because I explained to you that I like really complicated legal wonky issues, I think that as a judge you get to hear such a wide variety of issues, and you get to decide these wide variety of issues and have a real impact on people's lives, that I think it would be a really interesting.
All right. Somebody have a question for Mr. Sprague?
Don't be shy.
My name is Julia, and I had a question for you. Do you have set legal strategies that you use depending on the type of case?
Or maybe depending on the type of panel that you see, because you're more appeal court, right?
That is a question I'm not sure can be given a universal answer. It depends on the issue, and it depends on what side you're on, and it depends on the panel. Arguing on behalf of the appellate, where you know that you have some, where the legal standard favors you, you're going to make different arguments because of the seat that you're sitting. When you're the appellant, you're going to also, I think, do things a little bit differently because of where you are. would say that is universal. One thing that I would say that is universal has not to do so much with arguing with the court in oral argument. It has to do with briefing, and that is you need to say things. It's more persuasive to use fewer words. And when you write and you're trying to argue a point, if you cloud your argument with a bunch of unnecessary verbiage, the eyes of the court just kind of glaze over and they go into a stupor, and you're not convincing anybody.
Stupor.
Nice. He's actually, I know it sounds funny, but he's very accurate about what he says, because we read a lot. So if you give us a 100-page brief about something that you could have said in 22 pages, it focuses us to what we're going to be talking about, and it's appreciated.
No, and let me just build on that a little bit. Like, it's hard to express to people who kind of don't live in our world, but there are some things that are just so, you just assume are universally known. And you know that you have experienced lawyers, then judges, then appellate judges, and I personally would not waste words briefing, like the standard for summary judgment for issue, because the court knows that.
And for example, we talk about the panel. I know it's different because you guys just came from Jacksonville and we've just been realigned, but us on the panel, we're all trial judges first. So we've all been through many trials. So we understand how trials operate. So explaining to us, well, this is what happens in a trial. You only have a limited number of words that you can use in a brief. It used to be pages, but the Florida Supreme Court decided to go word counting instead of page counting for reasons that I guess they can best explain. So you have to choose your words carefully and concisely to help get your point across as best you can.
No more than 13,000.
Right?
Yes.
And you need to be focused in the issues that you choose to argue.
And it's funny to read the last page of their briefs. They'll say it has to be a certain font, because that's an important thing too up in Tallahassee. And it has to be a certain font, and it'll say, and oh, by the way, it's 12,214 words here. And one of these days I'm actually going to count these things and say, yeah, it was 12,219, pal. You gave me 5 extra words there. I got you.
You'd be surprised how as students, you're like given an assignment that has to be at least so many pages, right? You're struggling to get over the page limit. We're given a certain amount of words to stay under, and lawyers universally struggle to stay under that. And you have to be focused and concise in order to be persuasive.
Thank you, counsel. We'll call the next case.
Thank you very much.
Yes.
So we're going to have coffee after the second argument. You can stay or not. We appreciate that. We well argued on both sides. Thank you very much. You gave a good presentation for our students to watch.